Welcome to Module 3, Minors and Checking ID. In this module, we will explain the liquor laws about the sale and service of alcohol to persons under 21 and the possible sanctions when violating the laws, criminal, administrative, as well as civil lawsuits. We will cover how to identify a minor, what is and how to use a licensee certification card, and how to check an ID, how to identify an acceptable form of ID, and to recognize security features. We will also explain the correct way to calculate a person's age and how to identify altered and fake ID, intervention skills when dealing with a minor, and a house policy. Two of the most important duties you have in serving alcohol is not allowing minors or apparently intoxicated person, an AIP, to purchase, possess, or consume an alcoholic beverage. In order to possess, consume, or purchase, you must be 21 years of age or older and not show signs of intoxication. We'll talk more about the AIP in a later module. The sale and service of alcohol to persons under 21. To be blunt, the law has zero tolerance for any person under the age of 21 to be sold or served an alcoholic beverage. Here's what RCW 66.44.270 states. It is unlawful for any person to sell, give, or otherwise supply liquor to any person under the age of 21 years. A violation of this law is a gross misdemeanor, punishable by up to $5,000 monetary fine and up to a year in jail or both. Now, what happens if you sold or served alcohol to a minor? You may receive a criminal citation, which may cause you to appear in court, a criminal record, and a monetary fine up to $5,000 and possible jail terms up to a year or both. You and your employer may get sued and owe millions of dollars to someone you've never met. More on the third-party liability in a later module. The plain and simple fact is that serving a minor is a gross misdemeanor. When the city police and/or county sheriff cite you for selling alcohol to minors, they will issue a criminal citation, or they may refer that to the WSLCB, and the WSLCB officer will follow up by issuing a citation. Your establishment can have its liquor license suspended, revoked, or have a monetary fine. Have you ever seen an establishment get its liquor license suspended? Right at the entrance, or any place that the WSLCB deems necessary, this sign will be posted. Not only will you have lost revenue, you might have guests that become angry and you might never get them back. Also, you can be sure the rumor mill will get started and the story will get bigger and bigger. Please understand, selling or serving alcohol to a minor can go further than having legal sanctions imposed. You could end up in a civil lawsuit. Serving any liquor to a minor can lead to a civil liability lawsuit for any foreseeable act the minor does. You can even be held liable to the minor if that minor hurts himself or herself. It doesn't matter if the minor is intoxicated or not. If you served any alcohol to a minor and they have an accident that caused property damages and/or bodily harms to someone, you could be held liable in a court of law. If the minor doesn't hurt anyone else, but they are injured, you could be held liable to the minor.